Free in that beer?
I'm free in that beer.
I still recall the day I met her. An April morning just like any other. Just one of those things. And now I can't seem to forget her. The march of time, it fills my mind with memories of spring.
Coming to you from the West Coast, this is Politicos. Today is April 19th, 2018, and this is episode 82. Politicos is your weekly politics recap with West Coast perspective. If you haven't already, make sure to subscribe and leave a review wherever you found us. Follow us on Facebook and Twitter where we're at PoliticosPod, and support the show at patreon.com/politicos.
I'm Scott Blainboom.
And I'm Ian Bushfield, and today we're joined by...
Micah, I'm back.
Yeah, Micah, you're here to help us break down the Free the Beer case that you ran us through in December. And then we're going to use that legal knowledge to jump into the pipeline dispute again. First, though, I want to give a shout out to Ian Cromwell. We're using his brand new single Cherry Blossom as this week's intro music. You can find him on Facebook at Ian Cromwell Music. We also have to give a shout out to our premier sponsors, Lindsay Teds and Blake Hodson, for helping making the show possible. Politicos is in partnership with BC Today, British Columbia's brand new daily newsletter dedicated exclusively to BC politics. It's really how we're able to actually keep up as well as we do these days on BC politics. So take your chance if you haven't already. Sign up for that free trial. You get good BC content every day. And if you like it, stick around, use the offer code POLITICOS, and you get 25% off your ongoing subscription. Go to britishcolumbiatoday.ca and subscribe today.
Solid newsletter.
The other thing I want to shout out is I'm getting a ton of reviews for Canby Report, which is awesome, but I've also noticed we haven't gotten new reviews, especially new iTunes written reviews for Politicos recently. So go out there and give us 5 stars. Don't give us 4 stars. That's a waste of your time. It's a waste of our time. But those 5-star reviews help people find us and keep the show growing. So let's jump into the first segment with you, Micah. There's no such thing as a free beer. What happened?
Let's go back in time first. Just for those of you who could not stay awake the last time I was talking about the Como case, here's what happened. Como, this guy in New Brunswick, rolls over to Quebec, buys a whole bunch of terrible beer, like Molson M. No judgment on that part.
It's a little bit of judgment on that.
Okay.
We're drinking some Parallel 49 and something called Pacific Pilsner that was cheap, but it's from Prince George, so it's sort of local.
No craft beer for Mr. Como. And then he rolls back, and the RCMP, who is conducting a sting operation on him, takes his beer away and gives him a ticket for like $280. So Como gets counsel, challenges the ticket, retains a historian to provide expert opinion, and somehow, miraculously, they don't just win at trial, they overturn like a century's worth of Supreme Court of Canada jurisprudence. And the Court of Appeal washes their hands of it. They don't want to hear any of it. So it goes right to the Supreme Court of Canada. And that's where we're at today. Reasons were released. And I'm here to talk about what happened.
So I think you laid it out nicely there because to jump to the conclusion, the Supreme Court threw out Como. They upheld the appeal, siding with the New Brunswick government, and said trade barriers are cool.
If you're a Como fan, the oral submissions, which happened in December, were a lot like a train wreck. The written decisions are a bloodbath. Let's start at paragraph 3. I mean, things start going sideways 3 paragraphs in. And the first paragraph is like written by the court. I mean, it just starts bad and it goes downhill. And a lot of people were hoping against hope that somehow Como would come away with a victory. For
So,
those of you who
written by the court, though, just to break that down, is all the judges agreed, and they were so in agreement that none of them felt the need to kind of take the lead on it. They just...
No one signs it.
Yeah.
Everyone has a part in authoring it. That's the first red flag. Because for those of you who didn't listen to the last podcast that I was on talking about Como, during the oral submissions, Things went so bad that at one point, Justices Roe and Brown were openly contemplating ignoring Section 121 as if it didn't even exist. The only justice who was like throwing, and maybe he was just felt bad for Comeau's counsel, Moldaver was sort of trying to throw a lifeline out, and by the end of it, even he's having trouble getting over this tangled web of argument. Anyway, the oral submissions did not go well. The written submissions, the first chunk of it is the trial judge taking it right off the nose for essentially saying that the Supreme Court of Canada's judgments over the last 100 years are bad law. The last thing that the Supreme Court of Canada wants is for its decisions to be undermined by trial courts everywhere. There is a saying in law that bad law is better than inconsistent or unpredictable law. And to a certain extent, that does make sense. If you have people who feel like they can break the law in different ways, governments who aren't following the rule of law because they think that they can go to a trial judge and just convince them that the Supreme Court of Canada is bad law, that sets up a very dangerous precedent. And it does make sense that the Supreme Court of Canada would want stare decisis. They would want the lower courts to uphold the precedent of higher courts that's passed down over the years. So anyway, that's the first chunk, and the Supreme Court of Canada decides you had the trial judge had no right, no ability to make this decision. If you're going to overturn Supreme Court of Canada decisions, there's a very, very narrow vacuum where you can do this, and this wasn't even close. This is about beer. This isn't about assisted dying, for example. I'm sort of simplifying the argument here. That's not at all what the Supreme Court of Canada said.
Yeah, presumably the seriousness of it isn't the change.
Yeah.
It's how badly they screwed up
It's the amount of evidence you need to overturn something. In this case, the trial judge was relying on one historian, and not just the historian's view on what happened, the historian's view on what the interpretation of Section 121 should be. And the Supreme Court of Canada says, you are deferring your job as a judge to this historian. You are the person that's supposed to interpret Section 121, not the historian.
And there's big value for experts at trial, but usually I assume you'd have more than one, and you'd try to get differing opinions, and the court is still ultimately the arbiter of which. Like you sort of told us in December, there was this case in the 1920s also about beer, which basically set down the interpretation we have. And to get one historian, it reminds me a lot of the like Gorsuch style originalism that's going on in the US, where they're like, yeah, we know we've had centuries of a progressive evolving constitutional law, but what if we just got it all wrong and we just pretend we knew what the founding fathers meant when it agrees with us? And it seems like that's what the Comeau case was kind of built upon, but not even as good of a foundation as probably a lot of the stuff they're doing with originalism in the States. Like one guy.
It's not even as if there were no other historical investigations undertaken in the previous 121 cases. It's just that this is another view amongst many of what Section 121 was designed for.
So they can't rise to the level of breaking stare decisis, which you reference a Carter case, the assisted dying case. Interestingly, also a unanimous, I think, unsigned decision, if I recall correctly. But in that case, you had, I think, the BC Civil Liberties and Dying with Dignity Canada really going through reams of evidence in trial, which then worked its way up, and the Supreme Court of Canada was able to look at it and go, all right, the law was this. It's clearly unjust and is violating people's charter rights. In this case, it seems like Comeau's evidence was, it's annoying.
This is one thing that's buried in the Comeau decision that most people wouldn't discuss or wouldn't be interested in because it has really nothing to do with beer, but it is very important from a constitutional standpoint. What do you need as a trial judge to overturn a Supreme Court of Canada decision? And if you look at Carter, there were two massive elements in that case that did allow the Supreme Court of Canada anyway, to overturn years, decades of precedent. And there was a massive shift in public opinion in line with the living tree model of the Constitution, that the Constitution grows over time, that things change, things evolve, combined with that scientific evidence had gotten to a point where most doctors, most leaders in the scientific community agreed that it was unjust to allow people to die without dignity.
So my read on this is that it's the evidentiary component that's probably the weakest here. Because at least anecdotally, it seems like pretty much everyone who doesn't directly benefit, i.e. by running a provincial liquor monopoly, has come out in favor of the free the beer.
Although, is that a shift? Like, has anyone ever been like, oh, let's do the monopoly thing? No one says that.
The governments, but...
Yeah,
the governments, but not the people.
Yeah.
I'm sure, well, I'm not sure,
Well, we
but
did at the Prohibition thing.
this is what you could do with all the money you guys get from Lindsay Ted's. You could do a public opinion poll with Mario and figure out, how people have... Well, I don't even know if Mario can go back in time. Lindsay, you should send more money so we can try to figure out a way to public opinion poll in the past.
So coming back to Como, where does this leave us then? So we have Section 121, which says Canada should have some free trade. What does it say and how is it interpreted now? And where does that leave the state of beer laws?
Last time I was here, I read Section 121 verbatim, and the first thing that Scott said when I read that out is, well, that just sounds like we should have free trade.
And that's what Emmett McFarland said in Maclean's. He's like, this is the dumbest decision that's full of politics ever.
If you look at a plain and ordinary reading of those words, which is one of the tools of statutory interpretation, when you talk about admitting articles of manufacture of produce free into each province, it sounds a lot like you mean no burdens, not no tariffs, like no impairment for those goods. If you make a can of soda in Vancouver, you should be able to ship it over to Halifax without anyone getting in the way of that. You should be able to ship it directly to the consumer. And what the Supreme Court of Canada says is, no, it's not clear what that word free means or admitted free means. So let's look at a variety of different factors, plain and ordinary meaning, not persuasive, I guess. One interesting thing that I found as somebody who is supportive of Como but had my eyes open about his likelihood of success was that when the Supreme Court of Canada was looking at the historical context and they were trying to figure out what they meant by free, they couldn't find a reason why the word free was there by itself. Not free from tariffs, but in 121 it just says free. And the Supreme Court of Canada couldn't find a reason why that was, which left me a little bit wanting. But what the Supreme Court of Canada did find is that the other sections in the Constitution Act 1867, particularly sections 91 and 92, which are the classic division of power sections, the sections which enumerate what each level of power can do, what the federal government can do and what the province can do. They weren't convinced that Section 121 was a trump on those two sections. They felt like those two sections, which took up the bulk of the negotiations for the framers, weren't subjected to a later provision, particularly a later provision that's surrounded by other articles concerning taxation. And they made the point that sections 122 and 123 have already been spent, that they were created to help the colonies shift into a dominion, but that 121 doesn't have that same language. At the oral submission stage, as I said earlier, Justices Rowe and Brown thought maybe 121 should also be spent. Maybe we should just get rid of it and we should just use sections 91 and 92.
So this is like an evaporating theory of the Constitution where you start at the bottom and it just that one's
Sections
done.
roll away.
Yeah, you just kind of get rid of them one by one as they get boring.
What was decided, that is not,
That
by
is
the
not
way,
how
in
the
decision.
Constitution works.
The draining bathtub model of the Constitution. No, what happened is that the court decided that would be an overreach of the court to pick out different constitutional sections and just say, this one doesn't matter, this one doesn't matter. Drain the swamp. Drain the swamp model.
Right.
I think that's really what the phrase should be.
So I've read a lot that this basically says the only thing Section 121 really does now is says provinces can't put tariffs in between the provinces. Is that basically how it reads?
That's how it reads to me, Ian. And there's no change from Murphy, from Gold Seal. There are two questions to ask when faced with a potential contravention of Section 121. The first is there a burden on free trade? Just to use a colloquial phrase. And in this case, the court found that there was. Like, not allowing Como to go and grab a beer and come back, that is a burden on free movement of goods. But the next step is what gets a lot of constitutional scholars frustrated, myself included, and I think a lot of spectators, legal and non-legal as well. And that is, what is the purpose? If the main purpose of the legislation is to restrict the flow of goods and of products, well, that's not acceptable under Section 121. But if it's not the main purpose, it's an incidental effect. And if it's an incidental effect, free reign. That is, for a lot of people, bananas. Like, the threshold for legislation's main purpose to be impeding free growth, we're going to get to one in a second, but it's so high. And for most people who read Section 121, those things don't line up. Like, it shouldn't be the main purpose. It should be a substantial purpose, maybe, or something that is real and tangible, not anything that's not the main purpose. And by the way, the only method to determine whether it's the main purpose or not isn't really to look at the effect, because that's the first step. It's to look at what people are saying, what the other possible reasons for this are.
So basically, it's a very low test. It's just, is there a non-trade barrier purpose that could be found? Or is it a little bit higher than that?
It's basically that. Okay. Like, at a minimum, it has to be tariff-like.
So if a provincial government was a little short on cash and wanted to nationalize the liquor distribution, as long as they couched it in terms of public health, no scrutiny at all on that.
I mean...
Well, cannabis is going to be the next example, right?
Right. I mean, probably. The thing is, Section 121 is so weak now, I wouldn't offer an opinion on that.
So as long as your province isn't passing a law that says, we will literally tax this thing coming in because we want to.
I think that's the easiest case to make. Right. In this case, by the way, what the provinces, all of them except Manitoba, said was that there are very important regimes that we need to respect. And one of those regimes is health and safety. So one thing we do is we use the money we get, right? We just want to regulate liquor. That's our purpose. We want to regulate liquor. And the Supreme Court of Canada says, okay, that's the main purpose. Incidental effect is that you're restricting the free flow of goods.
Well, it's worth remembering Manitoba didn't say that because they just weren't there. Possibly because Brian Pallister was like out of the country.
I think that this was right after he had broken his leg.
Yeah. Out of the country.
Out of the country and out of his mind.
Presumably the Manitoba Attorney General would be keeping on top of this.
This is what we speculated on. We don't know.
Yeah.
To the listeners. We're not sure why they weren't there.
Maybe they had no strong feelings about this case. Unlike
Alberta,
every other province.
Alberta was there. I mean, Alberta came and they were supportive of Como. Relatively to the other provinces. NDP government sends their Attorney General who says we should have a different test. We should make 121 more broad. Como was saying, like, 121, no test. Are you restricting the free flow of goods? If yes, then no, like, unconstitutional law. And I think that was a bit too much for the SEC to swallow.
So my last question on Como, and then we'll move this into the next segment more on the pipelines and where this goes. But the solution then, if the courts say this is all legal, is political. And obviously the political incentives for all the provinces are to maintain their fiefdoms, as always. But what could a government, like, could the federal government change the setting? Like, if Maxime Bernier becomes leader of the Conservatives, and we'll get to his book in the quick takes, but if Maxime Bernier becomes leader of the Conservatives, becomes prime minister in the future, and says, we're going to free trade up this country, can he, like, pass a national law that, like, frees the beer?
No, and there are good reasons for that, by the way. One of those reasons is that provinces need to be able to regulate what's going on within their provinces. And this was a big tension that the court pulled on and that the attorneys general made their case on. Provinces need to be able to regulate what's going on within their provinces. Federalism was a huge topic of conversation in the oral submissions and in the written decisions, because what the provinces are saying is they want regional diversity. They want to be able to regulate what goes on within their borders as long as it's in line with the Constitution. And Section 121 shouldn't usurp that. Now, to answer your question, if you're the prime minister, it's not like you can go into the province and tell them what to do, although in a second we're going to say maybe you can in certain situations. But if something is wholly situated within a province and it's for the good of the province and the people in there and not necessarily for the people of the whole country, then there is a very important policy reason to allow the provinces to make those decisions. And the last thing I'll say on this is that I think for some of the judges, they were sympathetic to Comeau's cause, and they felt like liquor regulation and distribution was not a great, popular, wonderful example of provinces trying to use their constitutional rights to regulate within their borders. But they say that's not the court's place. The court's place is to interpret, not to determine which values are higher than others.
That brings up the fact that there's a lot of people who felt this, isn't a very good ruling. And there was maybe a political element to it. I saw Emmett McFarlane talking about that quite a bit. Do you think the court got too political in this?
By the way, being political, Emmett McFarlane would say by not making a decision, they're being political because they're throwing it back. I understand where the court's coming from. I'm disappointed because I think that if you take a plain reading and there are historical views that there should be more free trade than there is in this country. Maybe not total absolute free trade, but certainly we shouldn't stop at, is this a tariff? If yes, we're going to strike down the law. If not, then the law's fine. Like, I think there should be a little more room in there for people to be able to order wine from Nova Scotia if you're living in British Columbia and have it shipped to you directly.
Or you shouldn't get arrested if you drive across the border with a six-pack in your
He
hand.
didn't get arrested. He didn't get arrested.
Okay.
Well, he got arrested. He didn't get
criminally charged.
Yeah.
I can kind of see the case for, okay, the province can run its own, internal liquor sales, but then fining people who legally purchase alcohol when they're in another province and then just bring it home for personal consumption. Yeah, that starts to seem outside of the realm of a legitimate provincial government interest.
You can see the tensions here anyways, and if you're asking me, like, do I think that the court got it wrong? They want to protect what the decision was, but it does seem like Gold Seal is a bit of a fraud on the Canadian people. We decided this in 1920, and we're still suffering at its hands.
Well, no free beer in Canada. We'll have to magically all elect, I hate saying this, like libertarian conservative governments for like 1 year where they all just get together.
Every province needs its free trader at the helm.
Oh, it'd be a terrible year.
I mean, Scott, isn't this something you can do with all your power from running for city council at the moment?
Yeah, no, the Vancouver Charter does not have it. We're just at the point of literally yesterday making some tweets to liquor and grocery stores.
Store within a store.
Yeah.
Come on.
It's a little dumb. Well, moving on to segment 2, turn off the taps. The Alberta legislature followed through on their threat that we were talking about last week of tabling a bill to, turn off the taps for the oil coming into the province here.
So there's a ton of stuff to cover on Kinder Morgan, and I think we'll break it down into two halves. First, the legal stuff, and we'll start with Alberta's bill, and we are going to make full use of the resident lawyer legal analyst of the show, Micah. So Alberta
Intern. Legal intern.
Yeah, unpaid, as all good interns. So Alberta has tabled this bill. I think it's only its second reading, but it has full support of the UCP caucus, where they will give their minister the ability to restrict oil flows out of the province to any other province. It's neutral. It's obviously targeting at BC. Saskatchewan, Scott Moe, I don't know. He's trying to remain relevant and trying to live up to Brad Wall's popularity. So he says, I can do that too. I will restrict our oil from going to BC as well. I mean, the guy's got to get a name for himself. He's living in a long shadow. I guess the big question is this legal? Because what all my environmentalist friends on Twitter have been saying is the only good thing about Como is it means BC can restrict oil coming in, but what about Alberta?
Okay.
There's a whole bunch there.
Yeah, so much there. Okay.
Well, let's start with Alberta.
Let's start with Alberta. So what we just talked about with Como, provinces have a lot of rights restricting what's happening within their borders. Restricting what's happening in other people's borders, on the other hand, completely different. And the Supreme Court of Canada's decisions, their precedent is a lot more, let's just say, user-friendly. So if you are Alberta and you're making legislation that you know the primary effect is going to be in another province, the court's going to come down on you, because the federalism principle is that the provinces work together, but you get to dictate to a certain extent what happens within your borders. Now, if you start doing things within your borders that you know are going to have a massive effect on what happens on other people's borders, bigger than just, say, interprovincial trade, things going from one province to another, if you're, first of all, not treating all the provinces at an equal playing field, or B, knowing that the effects of what you're doing is going to affect one province severely, and particularly more than yours, you're running afoul of the law. And this is one area where legal scholars left and right are lining up and singing the exact same tune.
So when David Eby says Alberta's acting unconstitutionally here, you think most people are on side with him?
Solid ground. Certainly amongst the constitutional professors and scholars that I've been reading, and just in line with common sense. If you're British Columbia, you shouldn't be able to pass laws that are intended to only affect Alberta and harm their province.
So although I imagine some people, probably incorrectly, will try and equate we're not going to let oil come through our province with that, but in BC's case, we're not singling out Alberta oil, it's just oil in general.
Exactly. And that's one area, and maybe this will take us through to the next part of this discussion, which is, what is British Columbia going to do in terms of bitumen or other oil products coming into the province? And after this Como case, the courts have been clear that they're willing to defer to the principle of diverse federalism and the idea that provinces should be able to have a large say in what happens. Now, there's a difference between regulating your own liquor regime and an interprovincial work like a pipeline, which goes from one province into another province, and particularly one that is, the federal government would say, in the national advantage. Like, the Nova Scotia liquor regime has nothing to do with the country unless you're willing to make a couple leaps in logic. A trans-provincial pipeline carrying a very valuable resource, on the other hand, is a totally different matter.
So BC's argument, BC is still lining up its reference case, which it's going to try to get by the end of this month, sort of came about earlier in the year after the wine war stuff, where they mused about restricting the flow of bitumen into the province until we'd done enough science to figure out if it's safe. And that to me sounds like BC has a non-trade tariff reason. We want to protect our coastline, we want to protect our environment. Environment is a complicated shared jurisdiction between provincial and federal government. Does that then fall under the Como test of a reasonable restriction?
Well, let's take this question in two parts. The first one is on the reference question. The British Columbia government is going to pose a reference question to the British Columbia Court of Appeal, asking whether they're able to make, as far as I understand it, some environmental regulations surrounding the flow of oil, bitumen products, etc., into British Columbia, whether what they're doing is constitutional. This ability to ask reference questions has been used about a dozen times, five times since 2010 anyways, most recently in a question about the Elections Act and whether third-party advertisers could advertise without any restrictions outside of the writ period. And in that case, the court said, sure you can. I mean, it's just advertising, so you can't restrict that. In terms of whether or not British Columbia would be able to do that, to impose regulation restrictions, I mean, look, you have a work and an undertaking here that's going not only to the national advantage, it's going through different provinces. And from a prima facie sense, the federal government gets to make the regulations, they get to make the rules. But there's environmental concerns here. And the British Columbia government gets a say in what happens environmentally. And there may be ways to have it for both governments, to say you can have your pipeline, but you need to be able to limit it to a certain amount, or you need to have these certain environmental protections in place. Maybe the environmental protections can go so far as to make the pipeline unprofitable. I haven't seen the question. I'm not sure what it's going to be, but I would have a sense that that is what the British Columbia government is going to get at.
It could almost be this case where BC doesn't actually have any legal tools to stop the building of the pipeline. They can just stop what's going through it.
Potentially. And I'll wait to see what happens on April 30th. I mean, British Columbia has drafted its question, or Abby's office has drafted the question, and it's gone to, I believe, Cabinet, or it might be
Cabinet
a different
hasn't
group.
signed off on it yet, but that's the next step.
They have to look at it and discuss it and sign off on it, and it's not even the government that gives it to the Court of Appeal, right? It's the Lieutenant Governor gives it to the Court of Appeal. So it's got to go through all of these regulatory hoops. One quick thing is that I know that the British Columbia government was interested in providing a question to the Supreme Court of Canada. The problem is it would have taken quite a bit longer to get all the way up there, and they needed the assistance of the federal government. And it seems like the federal government wants to get the show on the road. They don't want any delays. They want things to happen quickly, and they probably didn't want to fight over the wording of a question.
Well, one of the things you mentioned, it's going to the BC Court of Appeal. I know the BC government has previously done reference questions to the BC Supreme Court, like the polygamy case, for example. And I think their argument for going to the Court of Appeal was, we want to kind of like bulletproof this thing, and we don't want to waste time like at the lower court with a whole bunch of interveners presenting evidence and arguing. Like, it's mostly a constitutional question where you just need some written submission, so that it sounds like they can go through the Court of Appeal relatively quickly. Probably not by May 31st if they're submitting on April 30th based on our court system, as far as I get it.
I won't comment on court times because I would imagine as a reference question you get priority. That would be an interesting thing to look at, actually, would be to see how quickly the reference questions got resolved. I mean, like the Elections Act question, this is a straight legal question. Mm-hmm. You don't really need interveners to present evidence to tell you whether or not you can pass environmental laws that might interfere with an interprovincial work and undertaking. This, to me, seems like a straight legal question. Can you do it? Is it constitutional? Yes or no? And the Court of Appeal is wonderfully situated to do that. I'm not only curious about the question, I'm very curious about the judges that the Chief Justice of the Court of Appeal would assign to do this case. I would be very, very interested to see who gets that.
So one of the things we talked about with the Comeau decision was that whether or not the barrier is the primary purpose is to discourage trade. Now, the BC government was very clear that they will use every tool in their toolbox. Have they shot themselves in the foot on this one by being very clear that this is a block in the pipeline question, not a we're going to protect the environment question?
You know, maybe a little bit, but I'll wait to see what regulations they're looking to pass. If they're passing regulations that would let the pipeline be built with just certain parameters, they want to make sure that there's X amount of dollars in place of insurance in case there's a spill, if they want to make sure that only a certain amount of oil is or bitumen is being pumped through the border every day, or I'm not sure what it is. Potentially, yes. If the regulations are set up in such a way as to suffocate the project itself, you might be onto something, Scott. If it's really there just to preserve the environment and British Columbia can make a persuasive argument, then no.
Well, I've heard Vaughn Palmer and others note the change in rhetoric that John Horgan and his ministers had, like the day they became government. They sort of realized we can't keep talking about stopping this pipeline. And even very recently, they've really shifted to we're protecting our coastlines. And that's a new buzzword. Protect the coast, protect the coast. I'm standing up for BC's coast. Got to protect the environment. So instead of talking about we don't want this pipeline, it's we want to protect our environment. And it's that way that I think they've managed to get around and move from. And it's because their lawyers and David Eby probably told them, if we keep talking about stopping this pipeline and we say we are against this pipeline, we're going to lose instantly. The environmental groups can all do that because they're not the government, even though people call them all activists and they say George Heyman's still meeting with them. But
can you help me out? Did Horgan say that while he was in power or before that?
Which part?
I think the exact quote came up during the campaign, but I'd have to double check on that.
It's at least some wiggle room for him to say, oh, people say all kinds of stuff on the campaign trail. But once I was in power, everything changed. I'm drafting these regulations as somebody in power, not as somebody who's on the campaign trail.
Well, and there's very specific wording in the confidence and supply agreement that he signed with the Greens, but that was before they got power, of how they would try to use the tools they can to stop the pipeline. But again, we don't have the words in front of us. So they've clearly wisened up to the difference between being government and just being on the sidelines when you can just shoot the shit. So that sort of handles Alberta's jurisdiction with its bill and BC's attempt to stop the pipeline with its reference question. Where's the federal government fit in this? Because the pipeline, as you've mentioned a couple times, is a larger project that crosses provincial barriers. Can Justin Trudeau just shove this through?
Justin Trudeau certainly thinks so. From my view, the federal government has far more power in this struggle than the British Columbia government does. It's an interprovincial working undertaking. The federal government has jurisdiction over that. But there are certain areas where British Columbia has some power and they can do certain things. And Justin Trudeau, at least publicly, hasn't appeared to respect that. But these guys, the federal government, the provincial government, are headed towards at least some kind of court battle. When the reference question is asked, the federal government is going to be put on notice and they will be able to make submissions. We'll see what they say at that point. But I'm on Trudeau's side to this extent. They have primary responsibility over this pipeline, and British Columbia cannot regulate in such a way as to, for lack of a better term, kill it. So depending on what Justin Trudeau's saying on this day or that day, he's right that the federal government has priority, but he is incorrect to even suggest that British Columbia had better get on board, because there are things that they are totally within their rights to do.
And what about any Indigenous nations that are still contesting through the courts? Do any of those have a realistic chance of success? I know that whole area has been very contentious at the Supreme Court and has kind of gone every way depending on the project.
Totally. One of the chief challenges when you're dealing with Aboriginal groups is that they're not all the same and they all want different things. And it's tough to make broad, sweeping assertions when you're dealing with individual nations that want different things, that have lawsuits for different things. So it depends on the First Nation that you're actually talking about. Some of them want the pipeline stopped altogether. And frankly, I'm not sure if that kind of veto power is available to them. But the simple breadth of all the different legal challenges makes it impossible to say, yes, there is at least one legal challenge that will put an end to this project. I don't see how you could have a single court challenge that would end the project altogether. But you could have a situation where the challenges have so much power, or they're handcuffing not only the federal government but also the private actors to such a degree that it would render the pipeline unprofitable.
All right, well, moving on to the final legal question surrounding this. A special prosecutor's being appointed for the case of contempt of court against Elizabeth May and Kennedy Stewart. Do you walk us through that?
Sure, I can walk you through a little bit of it. My greatest weakness is in criminal law. It's a area that I've never practiced in or don't have any training in. But a special prosecutor is usually appointed when you have a government official that's being charged with something. There is a conflict of interest that appears when you have an accused that's in government and you're being prosecuted by somebody who's also a government employee. And when that happens, the Crown Prosecutorial Service brings in external counsel, special prosecutor, to oversee the cases. And the cases for Kennedy and May are in criminal contempt, which I understand to not be the most serious cases in the world. They're trying like 10 people a day on this, and I can't imagine what the sentences would be. I would talk to Spratt and defer my views to him, but from what I know about having 10 people go to trial on the same day, the charges are not that serious. You have, like, just for reference, you have murder cases that take months to get through. You're talking about, like, 5 people by lunch? It's a completely different ballgame.
Or everyone getting charged on the criminal side? Or because there was a bunch of... Initially, this was a civil contempt case that the judge decided to upgrade. Is that going for everyone or just...
As far as I
PMPs?
know, the people who have been charged, because this was of such a public nature, the judge, I think it was Hinkson, but don't hold me to that, said, look, we make these rulings. These are court orders. You need to abide by the rule of law. You can't just violate court orders knowing that you're violating court orders. That sets a bad precedent. So if you're going to do that, we're going to charge you as a criminal because you know what you're doing is wrong. Not just civil contempt. And then that way, you have the company that is responsible for bringing 173 people to civil contempt charges. They can take a backseat to the public service. So now it's the taxpayer that is responsible for bringing these people to justice.
So even if we don't end up paying for the pipeline, we're at least paying for the pipeline's legal bills on one very narrow segment.
Not really.
Not
The
really.
pipeline's legal bills.
No.
But we are paying for people who have violated a court order to see 10 minutes in a courtroom. But again, Spratt's got to let us know what the charges are there because I'm not sure what they are.
Let's maybe pivot then to the political side of this. And you can feel free to jump in if you have strong opinions on any of this. One of the things that came out this week was this poll from Angus Reid. And the last data we had was a few months old that I think showed BC was split like evenly on this pipeline. And Angus Reid Institute went out and polled thousands of Canadians. So they have like 1,000 British Columbians and enough to get a good sample across the country. And they found that 65% of Canadians are actually against the BC government at this point, are thinking we're doing too much to try to block this. And not just that, but that's a growth of 10% since February because they've been repeatedly polling this. So Canadians are kind of turning against BC as we get more and more strident about this issue.
Yeah, that was the most surprising thing about this, is that the longer this has gone on, the more popular the pipeline has gotten. It's
a little bit different of a story here in BC. 54% are in support of that, but that's still up a few percent from 48% in February as well. It shows BC is starting to be a bit more in favor of the pipeline than against. When you get into the regional numbers, Metro Vancouver, Vancouver Island, there are greater levels of opposition, but it's still plurality or majority actually who support the pipeline in both those regions, which is not great news for John Horgan. But I know there are polls out there, and I did one the other day that asked how many people are willing to commit civil disobedience for this. And that goes beyond just saying, are you somewhat in support or strongly in support, to Are you like willing to face those criminal charges for opposing this pipeline? And it'll be interesting to see where those come out, because it's one thing if a bunch of people are soft supporters, but then you have a bunch of people willing to literally break the law to stop it. That can really throw your plans in disarray. Of course, the bigger issue for Horgan is if he throws in the towel and supports this pipeline, Andrew Weaver's going to burn him and bring this government down.
Yeah, and of the respondents, only 21% said this was going to be a serious factor in their voting. And I imagine that civil disobedience number will be a small fraction of that.
The other parts of this poll that were interesting, it did show pretty high levels of concern around oil tanker spills, which to me says Horgan's "we need to protect the coast" rhetoric is actually sinking in, or else that's what people always thought.
It definitely seems to be more effective than the climate change argument on this one.
They also did a nice split on the, is this worth the risk for the economic gain, or should we, prioritize the risk? And in BC, that was split evenly, with 35% saying the risk outweighs the gain and 35% saying the economic gain outweighs the risk. And then another 30% who are just like, yeah, they're about equal. And so there's just a perfect split in this province about like, is this pipeline worth it? Which is weird when a majority supports it. So there's people who are unsure or think it's about equal and are like, yeah, we'll go ahead with it. But I think the most interesting numbers for me was this, how many people think the Alberta and federal government should actually become investors in this, and where people were generally supportive of the pipeline, a majority then disapprove of the idea of the government basically buying it out. Nationally, it's 56% are against that idea. BC, it jumps to 70% for some reason, and Manitoba for some reason. They also really don't like the idea of the government investing in a pipeline.
Well, it's a dumb idea.
Alberta and Saskatchewan are the only provinces where a slim majority actually support investing in a pipeline, with 51 and 52% in support. Everywhere else is somewhat opposed.
I wonder how they feel about Bombardier.
I think you can take any semi-controversial industry and a majority of Canadians would be like, it's not worth investing in that. And it's one of those cases, I think, where the political capital, like the opposition generally to investing in an industry, isn't that big. Like, it's a lot of people are opposed, but they're not unified in any way. So,
it's mild dispersed disapproval
versus like an organized lobby group like oil industry or auto industry or something like that.
The Bombardier family.
So the poll numbers were basically immediately trumpeted by everyone to support their position, as always. I saw Keith Baldry at least going, the majority is growing in support of this pipeline, because that's his want. And a few of the more anti-pipeline advocates were citing the latter numbers about the investment. But yeah, very interesting to see the growing support for it. That was actually kind of opposite of what I would have predicted, at least in BC.
Federally I can see, or nationally I can see it, because it plays into that national interest thing and, doesn't affect someone in Manitoba at all. But yeah, locally it's odd to see this popularity grow. What would be interesting is to see a breakdown of that 21% that said it was a top issue for them, where they
stand. I agree. I was just thinking about that when you were saying, like, I suppose a small smidgen are the people who were arrested. I was thinking, like, but what about the people who are like super pro pipeline? Do they even exist?
They do. But they're not a marginal vote at all. They're solidly in the BC Liberal camp, or maybe the BC Conservative. One of the 5 voters for them. But yeah, I'm very curious to see where the marginal voter sits on that question, which this unfortunately just doesn't say.
I think the more interesting questions are at the sort of federal level, where you have Trudeau he didn't get really good numbers, because I also asked like who's doing the best at this, and I think Notley actually had the highest approval ratings. And Horgan had pretty strong approval ratings, bit lower than some of his previous stuff where he was, one of the top premiers in Canada. They're all kind of polarizing though, and there's no one who's super happy as far as I can tell across the country. How this pipeline plays out though, I'd be interested to see whether this affects the votes out in Quebec, out in Ontario, where I still can't see it being as big of an issue as here in BC and Alberta.
Yeah, I can't see the shift in votes very much one way or the other. At most, it'll play into did the Prime Minister stand up for a national interest?
But over in Quebec, the provincial government there decided to intervene in this debate as their Canadian Relations Minister, which I just learned they have, of course, sent a letter to Trudeau telling them not to ram projects through provinces because Quebec has a interesting relationship with federalism and doesn't like the idea of the federal government stomping on provincial territory.
Yeah, and up until the last few months, Alberta was more or less the same way.
Quebec famously, at the provincial level, I think, and definitely at the municipal levels, was very opposed to the Energy East pipeline. They didn't want that pipeline going through. There was lots of opposition, especially in Montreal and some of those areas. And they eventually won. They got that cancelled. And some of that may have been the jurisdictional questions. Some of that may have been the environmental. If it's more but in either case, those same arguments apply here in BC. And Quebec's nature of not really liking a strong federal government creates a weird BC-Quebec alliance that Trudeau partially used to build his majority and maybe is now putting at risk.
Maybe. I can't see this toppling the Trudeau government.
But it's a matter of, will it soften his support there? Will he lose some votes or...
To see a couple Metro Vancouver seats go in NDP, that's election, but I don't think it'll swing things very far.
And finally, on this pipeline discussion, Kinder Morgan came out today or yesterday with a new update. They pitched their ultimatum last Sunday saying, you have till May 31st. And more recently, they said, based on how this country has been going the first 10 days of their ultimatum, they think it may be untenable to actually build this pipeline. And they're leaking that out, and they're letting investors and everyone know that they're pretty cold on their feet. And this, I think, confirms my theory last week that they're entirely not committed to this project and just desperate to get the government to make it work. The federal Liberals, for their part, responded somewhat intelligently today, where someone at CBC was talking to the people who are out at their conference out in Halifax that's happening this weekend. And some sources started leaking, well, we're in talks with other Plan B options. Maybe another oil company or some consortium could be convinced to buy the stake in this pipeline and do it instead. Which, if Kinder Morgan was desperate for the government to invest, you then suddenly have competition taking it over. Kind of undercuts their play for free money.
Yeah, I'm really curious who those unnamed other companies are and would they be willing to sink a bunch of money into this given the challenges Kinder Morgan's facing?
Oh, is the federal government bluffing to call Kinder Morgan's bluff? That's not a bad theory. In a way, I still think this pipeline is just like on the borderline of being economically feasible. And so Kinder Morgan's just trying to get themselves out. And if the federal government can play another angle, it's just so on edge.
I'm curious if the reference case will change anything. If the results of the British Columbia Court of Appeals finding will change anything. And then if that's appealed, you're just pushing the estimated start date of this project back further and further and further.
Well, one of the things that I think we've thought the BC government's basically doing as their strategy is just delay and delay to make it more economically feasible. Sort of how the BC Liberals pushed Site C past the point of no return. You can just do that to Kinder Morgan in the opposite direction. Well, I'm sure we'll have lots more to say about this damn pipeline for the next 5 weeks or whatever it is until the end of May, and probably beyond that. Going into our quick takes. First, Andrew Weaver had a weird day this week. There was a debate on this bill about providing money to people with PTSD and supporting their families, and he wanted to make some amendments to it. And he'd asked the BC Liberals how many questions they were going to ask, and they told him they were going to use up as much time as they could. So he basically said, all right, I'm going to go do work in my office. And he does work in his office, and he comes back to the house. And when he gets back in, he'd missed his chance to pitch amendments. And then he threw a tiff. He was basically super pissed off that the BC Liberals threw him under the bus in his view because he couldn't be back in the legislature fast enough to pitch his amendments when it's his job and duty to be there to move them.
Yeah, it's just weird. You know, if he's not there, that's kind of his fault, and you really has no one to blame but himself on this one.
And his way of showing his displeasure was to launch into the start of a filibuster where he could talk for up to 2 hours, and he ended up talking for an hour and a bit. I think Keith Baldry or Vaughn Palmer or someone said on Twitter, Andrew Weaver talked for like 45 minutes about nothing because he was angry. And then Andrew Weaver, in the most Andrew Weaver moment, corrected him on Twitter to say it was over an hour. You can read the times in the Hansard.
It's so senseless.
And Weaver's not in government, but there's a lot of things he wants the BC NDP to do. And if he's killing legislative time to filibuster, he's only hurting the NDP. So it was a very weird point this week that no one really understood who watched this closely.
Yeah, Andrew Weaver has a tendency to kind of go off script sometimes and do some weird things, and this was one of those times. And
Forget about off script. Dude goes off the rails on Twitter. He reminds me a lot of people who like wake up at 3:00 in the morning and try to solve all of the internet's problems.
So the bill passed without Andrew Weaver's amendments. I was saying before we started recording, this is something Elizabeth May would never do because she is glued to that chair. She got her seat in the House of Commons, and she will use every second she can to be in it. And credit to her, she works hard at it. But missing a vote and then blaming the opposition for not asking more questions.
Like, show up a little early, you know? What are you doing? You take a late lunch. Like, show up a little early.
Do your work from your chair. That's what they're all doing anyway. So not a good moment for him.
well, moving on, David Eby's introduced a bill that would take away driver's licenses from people with outstanding child support or spousal support payments. So this is Bill 10, and it would give ICBC the ability to immediately cancel a driver's license. And like currently right now, they can not renew if this is the case, but this would just speed up the process.
So the goal here is to try to get people who haven't paid their child support to do it by saying you don't get to drive anymore. I guess the government doesn't have a ton of tools to try to incentivize this, and so
they can already garnish wages. There's a whole bunch of stuff they already do.
So they have other tools. Kyla Lee, who we had on last week, who has launched her own podcast called Driving Law, because not only is it about law of driving motor vehicles, it's also trying to drive a change in the law. And she pointed out on Twitter that is a pun. So check that out. I haven't actually listened to it yet, but that was a fun interview.
Which Andrew Weaver immediately corrected her on that it was not a very funny pun. I'm just kidding.
No.
Weaver didn't do that.
Kyla writes on Vancouver is Awesome on her blog there about this change. This is a terrible idea that will only cause further child support arrears and cost taxpayers money.
It's kind of hard to argue with that because this doesn't make a huge amount of sense as a way to incentivize payment because there's one of two things are generally the case. Either someone's deliberately ignoring it, in which case they're probably also the type of person who isn't going to be bothered by a little thing like having a suspended license get in the way of their driving somewhere. Or it's a case of they're having trouble making ends meet and taking away their ability to get to and from work is going to make that a whole lot worse. And, it's one thing for like us here in Vancouver who could, substitute busing pretty easily for most of our commutes. But, if you're out in Prince George or somewhere, losing your license, that can actually really hurt your ability to hold down a job.
So yeah, weird play. Maybe it'll get cleaned up as it moves through the legislature, or maybe the Greens will go, this is a stupid policy, let's just not support it, and it will die.
Several other jurisdictions have these types of regulations, so we wouldn't be the first.
That doesn't mean it's a good policy.
No, just to say that Ebbie's not pulling this out of nowhere.
All right.
Yeah, and like we said, they already have the option not to renew driver's licenses, but it just seems needlessly punitive when there's already the option to garnish wages, which should be able to take care of most of it.
I'm a big fan of the carrot approach. I think a lot of the time the nudges, and this is more of a stick that's not as effective probably in the long run. A different thing the government announced today, though, that I'm a bit more excited about is they are ending the server wages in this province. So BC has a minimum wage that they now have a path to $15, but there's always been a couple classes of people who don't get that. Your bartenders, your waiters at restaurants you go to, farm workers, and a few others. The BC government has now announced, following recommendations from a few different task force, that they're going to be getting rid of this. And it's not going to be an immediate thing, but by 2021, they are going to phase this out and everyone's wage will come up to the same level. And we won't have this weird exemption for some people.
Yeah, seems like a reasonable change. Not much else to say on it. And finally, Maxime Bernier's had an interesting couple weeks with a book that was coming out and now is not, about the Conservative leadership race, I believe, and then kind of his ideas about Canada, and, well, it landed him in a little hot water.
Bernier's pitch for this book was it's his ideas book. You know, he was running for leadership and then he didn't get it, so whatever. He wants to put his ideas out there, his libertarianism, all that kind of stuff. What got a lot of attention was he released what was apparently just a couple paragraphs from the book, which was the only paragraphs he actually talked about the leadership race. We won't know. I'll get into that for a second. But in those paragraphs, he says Scheer won because of, quote, fake conservatives. That is, people who signed up just to defend supply management.
So there were definitely some people who signed up as a result of that, but it's also a leadership race. Signing up people to vote for your vision of the party, or trying to keep people completely have the opposite view of you out of the leadership role, is pretty much par for the course on this sort of thing.
But that kind of allegation obviously generated a lot of attention and possibly, we don't know for sure, some internal pressure, because now Bernier, Mr. Freedom, Mr. Let's debate ideas, has said, it's not the time for me to publish a book, and I don't really want to distract from what we're doing as a party.
Yeah, and he's not entirely wrong in the sense that it was a very close call, and if a few other people hadn't voted the way they had, he would be leader of the Conservative Party. Remember, it came down to the final ballot on 14 rounds. Through which Bernier was leading the entire night up until the last round. So there's definitely a question there on, how things could have gone. But at the same time, it does kind of undermine the authority of the leader to suggest that their election wasn't entirely legitimate, which isn't what you want when you're less than 2 years out from election. You're starting to think 2019.
Yeah, if Diane Watts or Charlie Angus released a book tomorrow that suggested Andrew Wilkinson or Jagmeet Singh stole the leadership, that'd be a pretty hot item in the Canadian political junkie scene, which would then trickle out to the newspapers, and people would start to look at those parties and think they're rather corrupt and maybe shouldn't be given power.
Or just that that particular leader is not as good as people think he is.
And doesn't have the legitimacy.
Yeah, and at least Scheer's not the greatest leader, so he doesn't need any problems from inside the party, because he has enough problems from outside the party.
Scheer's done a good job of expelling other leadership candidates, not necessarily actively, but like Brad Trost lost a nomination bid for his own seat, and that's not necessarily Scheer, but
Yeah, I think it's interesting to see that who lost that, and they were the kind of less well liked by people.
And Kelly Leitch is gone.
Yeah, Kelly Leitch and Brad Trost. Their vision of where the Conservatives should go weren't as different from Andrew Scheer's as some of the other people who ran who are still around, including Maxime Bernier.
And Michael Chong.
Yes.
But no one hated Michael Chong, other than maybe the really...
There was some booze within the party a few times when he came
pitched his climate stuff.
Yeah, but most of the people who ran for leader who were MPs got shadow cabinet positions, and like they were kept around. And if I was Andrew Scheer trying to keep my rivals at bay, Kelly Leitch and Brad Trost are not the two people I'd be worried about. It would be Maxime Bernier, who's hasn't exactly been subtle about his desire to be Andrew Scheer's successor, ideally sooner rather than later.
So I guess we'll have to wait on Maxime Bernier's book for a little bit longer, but the knives are circling surprisingly early in that party.
Yeah, I think we might be in store for a kind of Paul Martin, Jean Chrétien sort of internal party battle that'll linger on for quite a while.
Good news for Justin Trudeau.
And my prediction is that when Andrew Scheer almost certainly loses the next election, those knives will come out and we'll probably be back in another leadership race, and one I expect Bernier will probably win.
And I find it passing strange that...
Well, resurrecting the Best of BC Poly segment, since there was finally some good tweets out there this week.
Including one of our tweets on the podcast account, which someone suggested, and we'll hold off on self-promotion here. So, bring us other people's tweets.
But do follow our Twitter account,
yes,
at PoliticosPod.
Because there are clearly things that are Best of BC Poly worthy there. We just don't want to toot our own horn that much on this segment. We want to kind of highlight the other people's contributions.
We will shout out past guests of the show like Justin McElroy, J_McElroy, who tweeted, "John Horgan has found a new favorite phrase, passing strange. He's used it 5 times in the last 9 question periods." And then he followed it very quickly with, "Make that 6 times."
What does that even mean? I legitimately have no idea what passing strange refers to.
It's a perfect Venn diagram of like weird John Horgan aphorisms and like Justin McElroy's affinity for statistics and like weirdness that circled in this Venn diagram. And thank you, Justin. If you do see other good tweets, funny ones, we're looking for wit, we're looking for not too partisan, send them to us, DM us, hashtag BestofBCPoly. I kind of like the segment, but if we don't get much, it doesn't exist. So this is up to you, listeners. Monitor Twitter so we don't have to.
And that has been Politicos. Find links to stories we mentioned in the show notes at politicos.ca. Make sure to subscribe or listen to podcasts and follow us on Facebook and Twitter at PoliticosPod. Leave us a review and let us know what you think. Support the show and get early access to our interviews at patreon.com/Politicos. And if you have ideas for the show, feel free to send them to us. Thanks for listening.